There was no certain outcome of the trial.
Even if Bryan Kohberger is guilty, the prosecution had a weak case.
I think there is going to be a lot of other evidence.
There's people out there that think the whole thing's fishy. In the aftermath of Bryan Kohberger pleading guilty to all counts against him, there are a lot of questions in this episode of About the Law. We're going to try and get answers to those questions, at least from a legal point of view, from an expert. I'm Andrew Myers. In this episode of About the Law, we will look at getting some legal views on what was going on with Bryan Kohberger pleading guilty. Joining me is Kelsey. Hey, Kelsey, how are you?
I'm good. How are you?
Good. You have a lot of questions about this, don't you?
I do. And a big one is, can Bryan Kohberger make a profit off of a book or a movie based off of this case, or does Idaho have a law against that?
That's a really good question, and a lot of people have that question. I haven't really seen a concrete answer anywhere else, except with this interview that I did with a former president of the Washington State Criminal Defense Attorneys Association. Attorney Kevin Curtis has been with us on this program in the past. He works for a large firm in Spokane, Washington. He is actually a consultant with one of the NBC stations out in Washington State, and he was good enough to give us some time. He's been practicing law primarily in the criminal defense area for 44 years. He has covered some very high-profile cases. And so let's go to Kevin, see what he has to say. I'm with Washington State Criminal Defense Attorney Kevin Curtis. Kevin, you work for a firm in Spokane, and you've been practicing criminal law for what, 44 years?
That's correct. Good morning.
And it's good morning. It's good to see you. I guess the first question I have for you, were you, like a lot of us, shocked when you heard early in the week that Bryan Kohberger was going to plea out in this case?
Yes, I was very surprised. I was contacted by a local reporter here in Spokane, Washington, with the NBC affiliate, indicating there were rumors that was about to take place, and I was very surprised.
What were your feelings? I assume you watched that plea hearing either live or played back. What were your feelings as you saw that?
Well, I was a little bit surprised as to a couple areas. Obviously, a change of plea hearing, I'm very familiar with those. The court's going to do two things. They're going to, number one, ensure that the plea agreement is in the interest of justice before they accept it. And secondly, they want to make sure the defendant is making a free, voluntary, and intelligent decision voluntarily, with knowledge of all of their trial rights, what they're giving up, what the agreement is, so that the decision to plead guilty doesn't get reversed on appeal. So that aspect of the hearing didn't surprise me.
Okay. And then, of course, as you know better than I, there has to be a factual basis, and there was a recitation of facts. A couple of facts were kind of new, and most of it was just stated a different way, but the factual basis didn't really have any big surprises, did it?
I did not think it had really hardly any surprises at all, although I think we had a teaser from the prosecutor when he first stood up. He seemed to indicate that there would be some new information not available to the public, but I really didn't hear any. So factually, we really didn't learn much of anything that we didn't already know. Secondly, I guess from a surprise standpoint, there's two things that stood out in my mind. First, I would expect in a case of this magnitude that the agreement would have required the defendant to cooperate with law enforcement in terms of full cooperation as to why the crime was committed, how the crime was committed, that type of information, because that information is obviously of importance to the public, but that's secondary. I mean, to the victims' families who have so many questions about why. So I would have expected to see that as part of the plea agreement. Now, maybe there's a side agreement where that will take place. It's not written into the plea agreement, but that wasn't there.
Well, as I'm sure you've heard from following the news, and I know you comment on the news, the families, some of the families are extremely outraged that Mr. Kohberger, at least at this hearing, was not required to give details, and that the state took the plea and allowed the plea, without a full accounting and without a trial. And the trial, they would have thought, would have gotten into the nitty gritty and the details and why and who was the target and all of that. Do you think that the court or the agreement between the prosecution and the defendant was wrong in that it did deny not only the families, but everyone those details?
Well, let's break that down into a couple different parts, perhaps. The information from the defendant as to why and how would not necessarily have come out at trial. What may have come out at trial is additional evidence from the crime scene and evidence from before and after. But if more likely than not, Mr. Kohberger is going to testify, is not going to admit he did it if it went to trial. So we won't know the how and the why through a trial. I think if there is anguish from some of the victim's family regarding the plea agreement, it was the manner in which they were contacted, and it was the removal of the death penalty from the case. Other family members were in support. I've said this before. There's a lot of factors that go into account in removing the death penalty and accepting an agreement with the defendant. Is it in the interest of justice? The court didn't spend much time dealing with that factor, but you take into effect the seriousness of the crime, the victim impact, community safety, a lot of other factors. And the fact that Mr. Kohberger will die in prison now and that is assured, is obviously a strong factor in favor of the deal. So is it in the interest of justice? And again, you take into account saving the pain and suffering and trauma of the victims' families, the witnesses. Then you go to the costs, the uncertainty of a conviction, the uncertainty of a death penalty. All of those factors lead to the plea being in the interest of justice. The more difficult question, which people will disagree on, is it in the interest of everyone? And clearly the answer to that to some victims' family is no. They would have preferred the case to proceed to trial, to pursue the death penalty, to see Mr. Kohberger executed.
Well, as an attorney, don't you agree that taking any case to trial, even if, people that don't understand trials say, oh, it's a slam dunk. Don't you think that in some regards, even this case, was a roll of the dice, and there was no certain outcome of the trial. There was no certain outcome in terms of guilt or innocent, and there was no certain outcome in terms of a jury agreeing to the DP. Is there?
No, there's never any guarantee. Now, death penalty cases, generally the cases that the state feels they have the most powerful evidence because they recognize that to seek a conviction in a death penalty, that second phase still weighs on the jury's mind, even during the guilt phase. So they want to make sure they have a pretty strong case. In this case, they did have a strong case when you really put all of the pieces together. I don't think there would have been much question about a conviction. Never 100% guarantee. I think the more significant question would have been in the mitigation or penalty phase, whether the jury would have unanimously agreed on the death penalty.
Well, yeah, there could have been one person that for religious or moral or personal or whatever reasons, it could have been just one person that could, even though they go through the voir dire and say otherwise, there could be one person that says, no, I will not send somebody to their death. And so, I don't see that as a foregone conclusion. Now, you said something I'm going to ask you about, and that is a lot of us out there, it's horrible. People have these terms, pro-burgers and defenders and guilters. I never put myself in any of those categories. As an attorney, I tried to tell my viewers all the way along that I respect the presumption of innocence. And I never thought from what we saw, and I know about the balaclava and the purchase of the knife and, the car driving around, I never saw anything that really, nailed it beyond all reasonable doubt. So what do you say to people like me who say, yeah, there was some reasonable doubt, and I think he had a chance at trial, even though there's a lot of evidence that was sealed?
I guess what I would say, and like you, I tried not to be judgmental in my discussions with you, and try to explain what I am seeing from both the state's perspective and from the defense perspective. I believe that what I would say to those who said, listen, there was reasonable doubt written all over this case, is that you can take each individual piece of evidence that was damning against Mr. Kohberger, and in isolation, you can argue that doesn't mean all that much. How many 2011 to 2015 white Elantras are there?
20,000 in that area, I think.
In that area. How many people have been on Amazon and bought a knife and its sheath? How many people drive between Moscow and Pullman and do so at night?
And a lot of people have balaclavas if they go hiking or if they go skiing.
Yes. So, how many people have that car that doesn't have a front license plate? How many people change their registration? How many people have their car cleaned out and their apartment sanitized? When you start putting those together, the odds of you finding somebody who also matches the physical description that one of the roommates came in as a white male in the right height, in the car, in the area, who's purchased a knife, and we're not even discussing the touch DNA yet, there are just too many things to where you're not going to find anybody in Pullman, Moscow, Washington, or probably anywhere else who really hits all of those boxes. So I do understand, and yes, you could pose reasonable doubt, and that is what happens at jury trials. Sometimes there's a quote mountain of evidence in the OJ case, but if you can key on one misstep by the prosecutor or raised doubt in one area, some jurors will find reasonable doubt. But that's what I would say to you is it is unlikely, if not impossible, to find an individual who matched all those boxes in the evidence that we know at this time.
All right, before I move to my next substantive question, I did some criminal earlier in my career. Now I do mostly, I'd say 95% civil. But when I'm talking to people on the other side, and we can't, we try amicably to reach, sometimes not so amicably, to reach a settlement. And if we can't, we just walk out of the room and say, well, we're going to roll the dice. This is the East Coast. Do they say that on the West Coast too?
Yeah, I've done civil, although my primary background's criminal, but I've done civil as well. And sometimes it's not the end of the world if you can't make a deal, correct?
Right. We have to try cases. We have to try cases.
That's why it has to go.
Here's my next question. You talked about the actual terms of the plea agreement. One of the terms of the plea agreement is that Mr. Kohberger waives all right to appeal or to bring a petition to reduce the sentence or any right of appeal. Okay, that's in there. His signature is on that document. All right, 10 years from now, things change, politics change, rules change. Someone comes in and says, oh, well, Mr. Kohberger was taken advantage of. He wasn't of right mind. He had, physical, mental issues. 10 years from now, 15, 20, I mean, he's a young guy. He's only 30 years old. So to me, he's a young guy. What's the chance that some kind of an argument can be made down the road and there would be some kind of an appeal or other challenge to all of this?
Yeah, well, we probably would call that there's two areas in which something could happen, maybe three. A collateral attack on the judgment, still unlikely. A change in the law, which does happen 20, 30 years from now. They may say, hey, listen, a sentence of life without the possibility of parole is either unconstitutional or we're doing away with it. Or three, a pardon. I think, and that would be from the state, since it's a state case, not the feds. I think any of those three would still be unlikely to result in his release unless we're talking 50, 60, 70 years from now. I mean, you look at the Charles Manson case and some of the individuals that were never granted parole. So even in either of the first two circumstances where there was a possibility through change of law or something, he still would go up in front of a parole board. I think there would be, a tremendous amount of outcry from the victims' families, from the communities, from the prosecutors, from law enforcement. And the nature of this case would make it extremely unlikely that he would be released.
Okay, I have a possible fourth area. Maybe I'm totally wrong, but before I move to that, a pardon would be politically dangerous, I would think, if anybody, as you say, 30, 40, 50, 60 years from now would attempt a pardon. That would be very politically dangerous. We have a case here in New England, the Pamela Smart case, and every now and then she comes up for parole, and we get our governors, every couple of years, and we've had governors say, not on my watch. And I would think that the Kohberger case, from a political point of view, would also come up to that. But what about habeas corpus? What about a habeas corpus attack that would, go around all of that? Could that ever be a possibility?
Well, it's a possibility you can file it. Nothing prevents you from filing a habeas corpus writ, but it's in violation of the plea agreement, number one. So you'd have to make some sort of finding that, your plea wasn't freely, voluntarily, knowingly made, that something, affected your ability to understand it, or number one. And number two, the only potential that I would ever have seen, for grounds for him to be able to collaterally attack would be a case in which there was some sort of new evidence that suggested he didn't do it. Once you've admitted that you've done it, I just don't see that there's going to be any traction on any of those areas. And yes, it would be political suicide. And remember, we're in the state of Idaho on top of that. We are in an extremely red state. So I do think that in this case, even if the law changed later on that banned the type of sentence, I still think he would be subject to parole hearings in which that would be denied and he would remain in custody.
What about, I don't know, and I know that right before we did this interview, you sent me some law, which I didn't have a chance to take a look at. Does Idaho have a Son of Sam law that would prevent Mr. Kohberger from ever profiting from writing a book or helping advise a screenplay? Or would possibly people want him to, but have all of the profits be diverted to the victims' families? What's the law on that in Idaho?
Yeah, Idaho does have a slayer statute, so to speak, is what they're called. It's tucked away in the probate code, actually. And in essence, what it says is, if in any way he benefits economically from anything related to the death of any of these individuals, that that economic benefit accrues to the decedent's estate.
What does that mean?
Oh, what does that mean? It means that if he did something and it made any money, that the victims of the family would receive that money rather than Mr. Kohberger or any of the people that he's designated in his will to receive anything that he has. In other words, he can't profit. Any money that is made from anything of that nature directly becomes the property of the victims, so to speak, or the victims.
Oh, really? So does a court have to make a ruling on that, or is that just automatic in the law in Idaho?
It's automatic. It's in the probate code.
Okay. All right. And what about a civil case? Would the families of Kaylee and Xana and the others, would the families have to bring an action, or are they just automatically going to get anything out of them? Because if they bring an action, if the Goncalveses, for example, brought an action, great. They could get their daughter was young. She was up and coming. She had a great education. She had a job and a nice future. And these are all things that go into a wrongful death case. They could get a judgment for $1 million, but it's a piece of paper. Is that what they would have to do to get anything?
Honestly, I don't know the mechanisms as to whether. I don't believe that they would have to file a civil suit and then get a judgment to be able to collect under the slayer statute. I think what they would be able to do is if there was evidence of an economic benefit accruing to Mr. Kohberger, I think they would simply bring an action under the probate code to declare, to seize, hold that money, and file an action under the probate code, and arguing basically that's not his money, that's our money. Okay,
the next question I have for you might be a little bit out of the actual legal area that you and I are both in, but there are people out there. I'm watching these. There are a few people out there that are saying there's something fishy about this. If you looked at Mr. Kohberger, he looked off. Ann Taylor was actually smiling. The prosecutor, Bill Thompson, broke down at the end of the hearing. There's people out there that think the whole thing's fishy and that it's a fix and that somehow the state of Idaho, and this is what I'm seeing, I'm not saying this, but people are saying the state of Idaho is so corrupt that they forced him into this. What about all of this out there that people say, no, he's, there's still a lot of doubt about this and they don't accept it?
Well, you're always going to have conspiracy theories on cases of national interest. That's what people do. It was surprising that to most people, including myself, that a deal was struck. We hadn't heard any ruminations about it, but that sometimes happens. I think a lot of these questions could have been answered, or a lot of these theories could have been displaced if, in fact, we did have what I've talked about, which is built into the plea agreement, a requirement for Mr. Kohberger to discuss in full detail the motive and how the crime was committed. I mean, until you have some of that information, people are going to argue that it wasn't possible. One person couldn't do it. He had to have help. There had to be this and that. And so I am again surprised by the lack of that information, and that just fuels these conspiracy theories.
The sentencing hearing is coming up on the 23rd of July. Two things about that strike me. I guess I'll break it down into two questions. Why even have a sentencing hearing? I mean, he's already agreed to 4 consecutive life sentences, $50,000 fines, which, if you're going away for life, what's the point of that? And so he's already agreed to those sentences and an additional, 4 consecutive sentences and then another 10 years on top of that for the, and I shouldn't laugh, for the felony burglary. Why even have a sentencing hearing? What's the point of it all?
Well, I think you're correct that there's only one sentence, well, not one sentence permissible. The judge does have the right to not follow the recommendation and go below that recommendation, even though Mr. Kohberger can't ask for that. But for all practical purposes, we all know what the sentence is going to be. I think the only reason that they didn't have sentencing take place was to give victims' families time to make arrangements to come. They do have a right to be heard at sentencing, and that's what the sentencing is about. Now, they could have put everything off for a couple of weeks, but once there had been an agreement between the defense and prosecutor for a plea agreement from both sides and from the court's viewpoint, you want to get that locked in as soon as possible so that there isn't a change of mind. So they did the plea. They could have done the sentence right at that time, but it would have deprived the victims. And now there are other victims as well. I mean, the primary being the victims' families, but there's a number of first responders and other people involved with this case who have been, incredibly traumatized by what they saw. And there should be an opportunity for them to be heard in court.
Yeah. At the sentencing hearing, some people are saying, well, Mr. Kohberger should really give us some details at that point. But as a criminal defense attorney and a former president of the Washington State Association of Criminal Defense Attorneys, do you think he'll say anything at the hearing or continue his right to remain silent?
I do not think that at the sentencing hearing that he would make any comprehensive statement that would speak as to the motive or how it was conducted. I mean, if anything, he would offer an apology of some sort, which it would be my guess, and that's all it is, just an estimated guess, is that he will make some very brief statement to the victims' families, but he may not. I sound like a broken record.
No, you don't. No, not at all. And I'm just thinking as you're saying that, I'm just thinking to myself, apology. What apology? What words could he ever say that the parents would accept. I mean, look at the parents. Most of them have been silent. Several of them have now spoken out after this. What could he? I'm sorry is not going to do it. I don't think.
No, there aren't any words. Whatever he does say, will be, number one, insufficient at a minimum, and then on the other hand, we'll get roasted by social commentary. So if I'm his defense counsel, I'm going to explain those things to him as well, and I'm going to leave it up to him as to whether he wants to craft a statement or not. I mean, it's his. If he feels that he wants to say something, he thinks it will help him, help others, help the family, etc., I'm not going to stop him from doing it. But you're right that there isn't anything that he could say that is going to lead to any mitigation, either of sentence or any mitigation of the family's feelings.
No. The non-dissemination order, the famous gag order, the judge brought it up at the end of the plea hearing. Well, why shouldn't I, terminate the non-dissemination order now? But both sides said, no, let's wait at least until the hearing on the 23rd. Why do you think the judge was willing to lift it now and the attorneys on both sides said no? What was that all about?
Well, that's a great question, and I don't know the answer. I expected that one of two things would happen. First, I thought the judge or the objection would be, hey, listen, because there's so many hundreds and thousands and pages or terabytes of discovery, we haven't really had time to go clean it up from a public release standpoint to remove personal identifying information regarding witnesses, etc., things like that. But that's not exactly the objection I heard. If that were the case, I would understand it, saying, okay, listen, I know that's going to be a huge process and you've been preparing for trial. So maybe that's kind of what they meant, and that's all that's holding it back. But otherwise, there's no reason to be withholding any of that information now. Maybe out of an abundance of caution, the judge or one part or the other thinks it could upset the guilty plea somehow or other. I don't think there's any legal basis to believe that. So I was a little surprised it wasn't lifted, or at least it wasn't the reason given for not lifting it. To me, didn't seem to have a whole lot of basis.
I think you'll remember back in the fall of 2024 when the case was sent down to Boise, Idaho, down to Ada County and to Judge Hippler. One of the earlier things that Judge Hippler did, I think it was in early October, if my memory serves me, was that people could apply, and there was actually a form, apply to get documents. And I did it twice, and both times Judge Hippler actually signed it, but I'm sure he could care less who I am or anything like that. But I actually twice delineated documents that I would like to take a look at. And twice the court said, no, you can't have them. So I gave up. I figured, why bother? I'm just wondering two things. One, after the case is all over, whether, people like myself, either through the court process or the Freedom of Information Act, will be able to get our hands on some of that discovery. Or B, it's a totally different question, I guess, now that I think of it. Do you think we'll learn stuff from the attorneys, either the prosecution or from the defense attorneys? Do you think we'll get details from them or not?
All right, well, let's start with the first one, and then maybe the second one really does go into some different fields. But
yeah.
So legally, here's how it's supposed to work. I mean, once the case is, quote, over, actually, even in Idaho, even before the case is over, the police report should be available as public record, minus personal information that needs to be redacted.
Sure.
Now,
names, addresses, dates of birth, social security numbers, sure.
Right. That's a massive amount of information. So normally what you would see in a large case is that you would have the records department or whoever is doing it, get all of that ready, and then both sides would look at it to make sure that it's been properly redacted. And then it's available in this case, it would be massive PDFs files or however they want to put it together, so that they would have it, ready to go as a kit to anybody who wants it. And I anticipate that's what's going to happen at some point in time once they have that ready. So that should all be able to go out to anybody. I think you, like many others, tried to get that information, which generally by law, once it's been sent over to the prosecutor and charges filed, you're supposed to be able to get it. But in this case, everything was sealed. The judge said here's another method of getting it, but that's, I don't know if you've ever been at a customer service place where they've got like a little comment jar, but you've got to pull the pin of the grenade to take a number. Bottom line is,
I always thought the comment jar was like the other side that you couldn't see in the back, just went right in the garbage.
Yeah, take a number and we'll be right with you. I mean, nobody was going to get that stuff, and that's it. Now, other details that could come out, we've already seen leaks. We know that people talk to the press media.
Yeah.
Is it from the defense? Is it from the prosecutor? Is it law enforcement, first responders, friends of friends? Sometimes we'll never know. Are there going to be all sorts of books and movies and datelines about this case for years? Yes. So we'll probably get maybe information that isn't in the police report. Again, whether it's true or not, that's, we're not going to know till we see what people say, what their sources are. And, some people will try to make money off of this, and some people will embellish down the line. But the first step is to get the police reports, see what additional evidence was in there, because we know there is additional evidence. I mean, we know there were footprints that were found that match. We know that there were DNA found on the handrail on a glove. We know that there were fingernail mixed DNA under one of the victims, and we know those were run, and a probability analysis was done as to the probability of it being Mr. Kohberger. So there's a lot of other evidence about the case that we don't know about publicly that will be released in the reports. And the second area, as the leaks, we'll just have to wait and see what happens.
So you just brought to mind something else that, I wanted to ask you about. And you've met my friend Yolie, the California attorney who often is on my podcast. And her question to date, even this week, has been, what about the leaks to Dateline? What about the fact that Judge Hippler was angry, I've got to say, with those 7-day orders to, supply anyone and everyone who had any access to the information, and he wanted to maybe get a special prosecutor? Do you think that will be pursued now that the case is kind of sort of over? Do you think he'll pursue that and they'll really go after whoever leaked the info to Dateline?
Well, I think that kind of depends on what the status of the investigation is now. If they have a pretty good lead on it and I think they know where it came from, I think the court would still be interested in pursuing it and doing something about it, if nothing else, to prevent it from occurring and to make an example. If it's really gone nowhere at this point, I don't think they're going to spend a tremendous amount of time and resources pursuing it. The main point was to allow both sides to be able to get a fair trial and not have it prejudice either side. Now that it's not going to trial, that primary concern's been eliminated. So I think how far it will go depends on how far it's gone to this date.
So going back 2 questions, I am going to request the materials that I had requested back in the fall of 2024. I'm wondering if it'll just be rejected, but I am going to request a lot of the material that I had requested before. And from your answer to my question when I asked you about that, it sounds like this case, Mr. Kohberger's, sentencing will be, history pretty soon. But this case is going to be around for a long time. And look at the Charles Manson case, that was around forever. And after the man passed away, new books came out. That shocked me. I actually bought a couple of. We've got the Son of Sam case. We've got the Bernhard Goetz New York subway shooter. We've got Ted Bundy, John Wayne Gacy. I could go on and on and on. So there are cases that people are still talking about, reading books, doing, podcasts, movies. So this case, I think, is going to be around long after you and I are gone.
Well, I agree. I mean, this case, obviously, the facts of the case are it's just so sad, so tragic, so senseless. But it will live on as a very infamous crime. Going a different direction briefly on your request, be prepared to pull a checkbook out, because I think what they're going to say also is, if you want everything we have, which includes all of the videos and the body cams and surveillance and the amount of other things, the cost, I don't know what they're going to put on it, but I'm sure they'll attempt to pass the cost, if you want everything, to the individual organizations to get it. So there might be some effort to pool among the major media sources. You might want to tag onto that. But yeah, we'll get those. We'll get the police reports, if nothing else, the basic investigative. I just, from my interest, a couple other notes that I made during the sentencing hearing, which I was waiting to see how Ms. Taylor would respond. And Mr. Kohberger, when they asked, are you satisfied with counsel? Have you done everything you believe you need to do? Do you believe you're prepared? Do you believe that you've received and been able to evaluate all the discovery to date? And we sure hear a flip in that answer than what we heard a week before, demanding a continuance because there's no way she could possibly get through all of the discovery provided.
Yeah, that was striking. That was a 180. That was a real U-turn on that one, that she wasn't ready. She had a lot more to go through. And then all of a sudden, Mr. Kohberger says, oh yeah, she did a great job. And
the judge directly asked her as to discovery. And she responded, yes, I believe I've been able to see and review everything sufficiently to represent him.
How do you go through 68 terabytes in 1 week? Because we've heard about this 68 terabytes, on and on and on and on and on. And as you just pointed out, the week before, she still hadn't gotten through it. So,
well, it just gives credence to the court's rulings each time, saying, hey, listen, I understand the volume, but all you're telling me is you have volume, and you're not, as best I can tell from the bench, not doing anything to get additional help to help get through it. And you're not pointing to any specific areas. You're just making a general statement time and time again. So I thought it was interesting and worth mentioning.
I still think, and I listened to every word you said about, the fact that no one piece, any one piece could have been explained away. The balaclava, skiers have those. The knife. Well, I talked to a different podcaster earlier this week, and he told me that I have a K-bar knife. I use it hunting. So all these things individually could be explained away. Okay, I get it. And then I was listening to you when you said that, but you put them all together, few people could really, look the other way on all of that. But I still think there had to be something else. There had to be a smoking gun. They had to have something with, 6 young people in that house that night at that time. There wasn't a Siri. There wasn't a refrigerator with a microphone going. I mean, you hear all these stories about how people have had a conversation about, gee, should we get a new carpet? Then the next time they go on Facebook, there's with all of the electronics, I still say there had to be a smoking gun. There had to be some shocker. There had to be some big thing. I don't know. Why was all that stuff sealed? I think that's my guess, is that there's some big, I hate the word bombshell, but there's something huge that none of us knew about. I don't know. I might be speculating, but I think there's got to be something else. There's got to be something else. Why wouldn't Mr. Kohberger, and this is backtracking a little bit, why wouldn't he just roll the dice and go to the trial? Why would he plea and give up his life? Why? He's only 30 years old at this time. I don't know.
Right.
Well,
I would tend to agree with part of your analysis, and that is, I do believe that there was other circumstantial evidence, or maybe even some direct evidence, that linked him even more than what we know to these crimes. And I think that probably deals with things like the DoorDash driver. We heard some time ago about evidence from his phone regarding potential attempts to communicate with one of the victims on Instagram that were rejected or put into a junk file. We know that there were footprints taken, but we never know from the evidence seized on warrants whether they match shoes. So I think there is going to be a lot of other evidence that we see similar to what we've seen that either puts him at the scene or links him to the crime. Whether there is anything, like a bombshell that directly has him fingered? My suspicion is no, because the defense would have known about that a long time ago. And this plea would have happened a lot quicker, I think, if there was something that significant in the evidence.
Yeah, I tend to agree with you, but I mean, I don't know. It's just, I think there are a lot of unanswered questions about this case. I disagree with people that say, oh, we don't think he was guilty, he was set up. But I do agree with people that say there's a lot more to the case. And so I have a feeling, I mean, I've really enjoyed our interviews that we've done over the course of this case. I have a feeling it's not over. I have a feeling that a lot more is going to come out. I have a feeling that you and I will be talking again in the future. So again, thank you very much for your time. I really appreciate it. I know you're a busy guy. And so I wish you well.
Well, I wish you well too. I have enjoyed our chats, and I don't do a lot of podcasts at times simply because the direction either hosts or other guests take these, and then it turns into what I believe not to be a very honest or intellectual discussion as to what really is happening within the criminal justice system. So I appreciate your approach, probably your journalistic background.
Thank you.
As well.
Thank you.
It's been a real pleasure.
Well, a lot of times, I do edit stuff, but your thoughts and comments are to the point where I can't edit it. It's got to run the way it is. And I know we've gone a lot longer than either one of us thought we were going to go, but I mean, I can't edit it down. Yeah, there are people that, they'll do, and I was guilty of this when I was in the media. They'll do a 40-minute interview and they'll edit out one 15-second clip.
Right.
I can't do that with you. All right. Thank you very much. I wish you the best, and have a great weekend.
Yeah, happy 4th, and say hi to Yolie for me.
I'll say hi to Yolie. It's a really big holiday weekend this weekend. You know why? Because on July 7th, 1940, Ringo Starr was born.
Richard Starkey.
Yes.
I love the Beatles, and I followed them. I should know more about them, but, talk about being in the right place at the right time when they decided to replace Pete Best, huh?
Oh, yeah, really. I have a friend, we'll cut this off, but I have a friend who knows absolutely everything there is to know about the Beatles. Who played what instrument, what kind of a soundboard they used, who was producing, who they brought in off the street to just do a sound. He knows everything. So maybe if you're that big of a Beatles aficionado, we will do it. And he's a person I won't name right now, but he is in the media. He is in the media.
You and I are close enough in age that in the 60s, that's what we were listening to on our transistor radios. And when they came over, I mean, teenagers growing up to the Beatles, I was 15, I think, when they broke up, and it broke my heart back then. I mean, they were, they obviously, for me, the major music influence in my life.
Yeah, you and me both. The very first record album I ever had was Meet the Beatles. My mother bought it for me. She actually liked that. Now, as they went into different phases, she stopped liking them, but I started liking them more.
I was 10 years old, and my babysitters won tickets to the Beatles concert in Hollywood Bowl, and they were supposed to take me, and my parents said I was too young, so I didn't get to go.
No, I never saw them either. I know people that saw them at the Suffolk Downs racetrack in Boston. I actually know people that went, but no, I never had that luck. Kevin, thank you very much. Thank you for your insight, and you have a great weekend.
Thank you. You too.
Okay, we'll just have to let it be with Kevin there. Good interview. I can't believe we ended on such a light note. Kelsey, do you like the Beatles?
I do like the Beatles.
That's cool. My favorite band of all time. Although I can't believe that we're ending this serious topic on a note like that. But anyhow, I wonder what our viewers would say about that we're talking about them. Anyhow, here are some of our viewer comments about this subject.
Number 5, Anna Christie, VP4IP, said, yep, if this Kohberger case had gone to trial, it would have been a not guilty or hung jury for sure. Thank God Kohberger took a plea deal, because there was a high chance, because of a tainted jury pool, that he would have walked, gone to see Jackson in Hollywood, and started writing his movie. You all spooked the prosecutors into believing Kohberger could walk. Some justice is better than no justice. You have all fallen on your sword.
Now, wait a minute. I take umbrage at this comment because, first of all, we don't know that it would have been a not guilty or a hung jury. It's a possibility. It's a possibility. And in our earlier episode, we talked about how that might be why the prosecution was so willing to offer the plea deal. But then that final comment about, you have all fallen on your swords. Well, I don't know about that. There are just as many YouTube channels out there that have been pro law enforcement as pro Kohberger. I don't think we fall into either category. I've said all along that as an attorney, I respect Mr. Kohberger's or any defendant's right to the presumption of innocence. That's just how it is in this country. So I just don't buy that. Where's our next comment? Number 4, Gem Grant, ASU. Not buying this story. None of it makes any sense. He pled guilty to make the story go away. He will quietly disappear under a new identity. I don't know. That's such a conspiracy theory. Do you buy that?
No.
Yeah, that's, the conspiracies are hard to give up for a lot of people.
Number 3, Riawahine said, even though Bryan Kohberger accepted a plea deal, is he allowed to file an ineffective assistance of counsel? If so, how does that change his case?
I really don't think so. I've heard people discuss this elsewhere. I really don't think so, because the judge asked Mr. Kohberger at his hearing, which we covered in the last episode, a number of questions. Are you satisfied with everything that your counsel did? Are you satisfied with your counsel? Are you making this determination to take the plea voluntarily and knowingly? So there's a school of thought that somewhere down the line, Mr. Kohberger say, well, I did feel that I was in duress. I didn't feel I could say anything about it, and that he could bring a habeas corpus petition. But as you heard Attorney Curtis say earlier in this episode, the chances of that are it's unlikely, and I would agree with him. Okay. This is from Cole Matako 9445. I apologize if I mispronounced that, but loved watching you cover this trial. The only thing I know about this case is that something has stunk to high heaven ever since the day I heard law enforcement say they wanted to destroy the house. Since that point, I have had one eyebrow raised. To this day, the only consistent pattern is that nothing makes sense in this story. I kind of agree with that. A lot of things didn't make sense, and I don't think that we're done with this case. What do you think about that?
I don't think we're done with this case.
Yeah, so many unknowns.
Number 1, Flora5398 said, even if Bryan Kohberger is guilty, the prosecution had a weak case, at least not beyond any reasonable doubt. That is why they agreed to a plea deal.
Yeah, I agree with that one. I definitely agree with that one. And I'm wondering why the prosecutors, Ashley Jennings and Bill Thompson, were walking out of that hearing with all those papers that they have in their, briefcases there, because they really Ashley said nothing. And Mr. Thompson basically said nothing that hadn't been said before. So anyhow, I don't know. So, we on this past week saw the guilty verdict. We saw the reading of Mr. Kohberger's, saying, yes, I agree. Yes, all of this was done with my free act, and it was all done voluntarily. So, the one thing that we always have to remember is that this case is about Kaylee, Madison, Xana, and Ethan and their families. Some of the families have been accepting of the plea. Others have not. We asked Mr. Goncalves to express his feelings on this channel. He has chosen not to respond. I've talked to the man before, and I would certainly, offer him this last opportunity to tell us something. But Kelsey, what are your closing thoughts today?
I think since there is so much that we still don't know, that there will be a book or a movie or something of the sorts eventually after everything is passed.
Yeah, I just wonder not if there will be a book, but how many books? I mean, people on the prosecution side, way back in the Charles Manson era, the prosecutor, Vincent Boyossi, wrote a book, a whole bunch of books came out after Mr. Manson's death. One of my regrets in life, not that I have many, but about 2 years before his death, Vincent Bugliosi appeared in Massachusetts, and I was toying with the idea of going, but I didn't go. And I would have had the opportunity to listen to him, to shake his hand, get his autograph, speak to him, but I never did. So people, let this be a lesson to you. Kelsey, let this be a lesson to you that take every opportunity you can, because you never know. You never know if it's the last time you've had an opportunity. So,
so true.
Yeah. So, yeah, I agree with you that there will be books. There will be more. There have already been several documentaries, and another one is coming out on Amazon Prime. They're going to be doing a documentary. So thank you all for being with us. We appreciate you being with us, and we hope that you all have a great day.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.
There was no certain outcome of the trial.
Even if Bryan Kohberger is guilty, the prosecution had a weak case.
I think there is going to be a lot of other evidence.
There's people out there that think the whole thing's fishy.